So let's begin today's session. So from today we have to start the part 4 and the chapter 7, that is the burden of the proof. So burden of proof means the burden on the party to prove a fact which is asserted by him in order to get a decision of the court in his favor. So there is a general rule: any party who asserts the fact in affirmative, and the burden of proof will be on that party only. Suppose, for example, there is a suit between A and B regarding the breach of the contract. So A asserted in the court he executed a contract with B, and the B denies. So here A asserted the fact he has executed a contract with B and he has answered in affirmative, and on the other side, the other party B has just denied the fact that he has not executed the contract. So here in this illustration, the burden of proof will be on A, who is asserting the fact that he has executed a contract with B. So let's start with the statutory provision. So section 104 is dealing with the burden of proof. It states that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. And when a person is bound to prove the existence of any fact, it is said that burden of proof lies on that person. So from the statutory provision we got to know two things. First one is that अगर कोई भी पक्षकार अपने हित में न्यायालय की फैसला अपने फेवर में लेना चाहता है, अपना कोई कानूनी अधिकार स्थापित करना चाहता है, या किसी का दायित्व को सामने रखना चाहता है ताकि उसका दायित्व पूरा हो सके, तो वह अगर कोई भी तथ्य को असर्ट करता है तो उसको ही उस तथ्य को प्रूव करना पड़ेगा। और जब यह बाहर उस पक्षकार पर उस तथ्य को प्रूव करने का बार उसके ऊपर होगा, तो इसे हम कहते हैं दैट द बर्डन ऑफ प्रूफ लाइज ऑन दैट पर्सन। सो लेट्स have some illustrations. So A desires a court to give judgment that B shall be punished for a crime which A says B has committed. So A must prove that B has committed the crime. So there is a prosecution between A and B. A is the victim and B is the accused person. So now A wants B should be punished for the crime which is committed by B. So here the burden of proof will be on A to prove that B has committed a crime, so that the judgment can be given in favor of A by punishing the B for the act committed by him. So after that, section 105, on whom burden of proof lies. The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. So when any suit is proceeded or any criminal prosecution is going on, so there is a level that court makes regarding between the two parties. So on the one hand there is a plaintiff and on the other hand there is a defendant. So on the one side the plaintiff side gives evidences, and on the other side the defendant also gives evidences to disprove the claim of the plaintiff. So after examining both the parties and appreciating the evidences of both the parties, जब न्यायालय दोनों पक्षकारों को सुनकर और उनके साक्ष्यों को एप्रिशिएट करके एक अपनी पर्सपेक्टिव बनाती है, अपना नज़रिया बनाती है, तो अगर प्लेंटिफ ने अपना सूट ऑन द प्रिपोंडरेंस ऑफ प्रोबेबिलिटीज प्रूव कर दिया है तो प्लेंटिफ का काम हो गया, और अब दूसरी साइड बर्डन ऑफ प्रूफ किस पर होगा? डिफेंडेंट पर। अगर स्थिति ऐसे ही रही तो क्या होगा, द कोर्ट विल पास डिक्री इन फेवर ऑफ द प्लेंटिफ बिकॉज the burden of proof is on the defendant. If any kind of no other evidence or any other fact is not brought in the notice of the court, so the court will pass decree in the favor of the plaintiff. So after that, section 106, the burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence, unless it is provided by any law that proof of the fact shall lie on any particular person. So the section 106 says that if any party wants to prove a particular fact and he wants the court to believe that fact, the existence of that fact, then the burden of proof will be on that person only, except when any law which is in force says that the burden of proof to prove that particular fact will be on a particular person, then exception will apply. But in general cases, when any party wants the court to believe the existence of any particular fact, then the burden of proof will be on that party only. So उसके बाद धारा 107, burden of proving fact to be proved to make evidence admissible. The burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. कई बार स्थिति ऐसा पैदा होती है कि जब कोई पक्षकार को अपना साक्ष्य प्रस्तुत करना होता है तो उससे पहले कोई ना कोई कंडीशन होती है या फिर कोई ना कोई नेसेसरी कंडीशन होती है जो कि न्यायालय के आगे प्रूव करनी पड़ती है। तो वह साक्ष्य को स्वीकार करवाने के लिए जो उसकी कंडीशन है, उसका बर्डन ऑफ प्रूफ भी वही पक्षकार पर होगा जिसने अपना साक्ष्य स्वीकार करवाना है। सपोज एज वी हैव ऑलरेडी डिस्कस्ड अंडर सेक्शन 26, दैट इज द डाइंग डिक्लेरेशन. So when any party wants to prove the dying declaration of any victim, before that the party needs to prove that the person who has given the statement has died. So here the burden of proof to prove that the person has died who has made the statement will be on that party only who wants to use the dying declaration of that person. ठीक है जी. So after that we have section 108. It deals with the general exceptions that are provided under Bharatiya Nyaya Sanhita from section 14 to I guess 43. All those general exceptions, when the accused person wants to use those general exceptions, then the burden of proof will be on that accused person only, be it any proviso to any section or any kind of special exception or any kind of general exception. Then the accused is the person on whom burden of proof lies in order to bring his case in general exception or any kind of special exception or in any kind of proviso in any other part of that Bharatiya Nyaya Sanhita. Suppose for example A is accused of murder. He alleges that by grave and sudden provocation he was deprived of the power of self-control. So there is a charge of murder on A, and he alleges that there was grave and sudden provocation. In case he proves the grave and sudden provocation, then his case will come under culpable homicide not amounting to murder. So there is a difference between murder and culpable homicide. So here the burden of proof to prove the grave and sudden provocation will be on accused person. So that's all for today. So we will be continuing from tomorrow from section 109, that is the res ipsa loquitur, which is the legal maxim which is connected with section 109. So from tomorrow we will be starting from section 109. So that's all for today. If you feel any kind of query or any kind of doubt, you can ask me anytime. So let's meet tomorrow.